It begins with a case, a written petition asking the Supreme Court to act. Petitions arrive by the thousands, year after year. In quiet chambers, 9 justices consider the questions, whether from a prisoner who believes he was wrongly convicted or a president defending his power as commander-in-chief. In a public courtroom, the great national questions are argued in a drama both austere and intimate. It has become a model for high courts throughout the world, but the Supreme Court of the United States remains the most powerful judicial body on earth. They deliberate and reach their decisions in private. "We are quiet," said Justice Oliver Wendell Holmes, "but it is the quiet of a storm center." Their legitimacy is in the Constitution, but their power rests on public faith in their independence and impartiality. The Supreme Court interprets a 200-year-old Constitution, safeguarding liberty, preserving the Union, and upholding the rule of law. The court poses for a group portrait whenever a new justice arrives. Though trained in the law, they deal with human dilemmas. They are people, not disembodied spirits. In all of American history, there have been just over 100 Supreme Court justices, serving an average of 16 years. Many remain on the bench twice that long, decades after the president who appointed them has left office.
I've had the honor of nominating Justice Rehnquist to be the next Chief Justice of the United States.
Presidents have always attempted to shape the court by their nominations, with mixed results. Supreme Court justices have rarely hesitated to assert their independence. The court's membership has always reflected popular sentiment through presidential nominations and the Senate's confirmation roll.
Once confirmed, all of us are primarily responsible to the law, to this institution, to your own conscience, and the public no longer has a direct ability to influence the decision through the ballot box. That's why that confirmation process is a very important thing.
Joining this court can be a humbling experience, or, as one justice said, being appointed to the Supreme Court is akin to being struck by lightning.
When I got here, some of my colleagues said to me, "You've got to give it 3 years. And after 3 years, it will not seem so overwhelming and so strange." One of them said, "Pay no attention to the 3-year rule. It takes 5. I think probably it's fair to say that you really start doing your work here properly when you forget that you're here, and that takes a few years.
They come to a court which is repeatedly called upon to draw the boundaries of government power, telling the President, Congress, and the states what they may or may not do. They cannot avoid controversy. But after 200 years, Americans have accepted the court's authority. It was not always that way. When the government moved to Washington in 1801, the Supreme Court was given temporary quarters in the unfinished Capitol. John Marshall, a promising young lawyer from Virginia, had just been named Chief Justice. Under Marshall, the court asserted for the first time the greatest of all judicial powers, striking down an act of Congress as unconstitutional. Behind John Marshall's statue in today's court building are inscribed the words of his opinion in the case of Marbury versus Madison. In a later case, Marshall wrote, "We must never forget it is a Constitution we are expounding." Under his leadership, the court made the Constitution an effective instrument of nation building. During the Marshall years, the new court rapidly earned public respect as a co-equal branch of government. 20 years later, the court faced the most divisive issue in American history. Dred Scott, a Missouri slave, claimed his freedom under an act of Congress. Under Chief Justice Roger Brooke Tawney, the court ruled that Congress had no power to ban slavery and that blacks could never be citizens, a decision that weakened the court's authority for years. The slavery question was finally resolved by the Civil War, and the Dred Scott decision is remembered as the court's great self-inflicted wound. After the war, the Constitution was amended to abolish slavery, define citizenship, and grant voting rights. The 14th Amendment told the states they could not deny due process of law or equal protection of the law to any citizen.
Many people would call the 14th Amendment the Second Bill of Rights. By that they mean that just as the Bill of Rights was put into place to protect citizens against federal power, the 14th Amendment has been used pervasively in our time to protect individuals against the excesses of state power. So it takes its place in the constitutional galaxy right alongside the Bill of Rights.
Today's court looks to the Constitution in the tradition established by John Marshall to resolve national problems. Justices Kennedy, Stevens, Scalia, and Ginsburg talked with law professor A.E. Dick Howard.
In a way, we have an advantage that John Marshall did not. We have 200 years of history, of detachment, in which we can see the folly of some ideas, the wisdom of others. So the fact that we're interpreting a document that's 200 years old is not just a disadvantage. It's in a way also an advantage.
Don't sign me up for that. I don't think the Constitution has become any more clear or means anything different from what it originally meant, and I guess that's just a difference in interpretive philosophy. But
we disagree, as you know, on some very fundamental things from time to time. But we really all share the same basic objective, and we all respect one another's good faith in trying to achieve that overall objective. There's just no basic disagreement among us on what's most fundamental in what we're trying to do.
We don't have the Constitution that was written in 1787 or even 1791 when the Bill of Rights was added. We have the post-Civil War amendments. We have the 19th Amendment. Remember that we the people was composed of a very small part of the people, in fact, inhabiting these shores. No woman could vote. People were held in bondage. Native Americans were not treated as citizens of equal stature and dignity. So those people do count among we the people our Constitution embraces today, although it didn't at the start.
The Supreme Court receives more than 100 new cases every week, about 7,000 a year. Most arrive as petitions for certiorari, written arguments attempting to persuade this court that a lower court ruling was incorrect. The court accepts very few of them for full consideration, about 100 a year. Newly arrived petitions, along with written arguments in cases already accepted, are sent to the justices once a week. In their chambers, each justice is assisted by a small staff of law clerks and secretaries, but each of them is individually responsible for deciding each case. As Justice Brandeis said, we do our own work. By the time a case arrives here, the facts have been established in a trial court. This court considers the legal questions. Did the lower court apply the law properly? Is the law constitutional? The justices meet weekly in conference to choose which cases the court will accept and decide, and to discuss and vote on cases which have already been argued. Chief Justice Rehnquist and Justices O'Connor, Thomas, and Breyer talked with Dick Howard about their work.
You're actually living the fact that people who wrote this document called the Constitution somehow managed to produce words that actually guide us in solving problems that occur 200 years later.
I think one of the most amazing things about the process for granting certiorari or denying it is the fact that every petition, whether it's filed by high-priced legal counsel or whether it's written by some prisoner sitting in jail someplace in his own hand, gets the same individual consideration. And in a country the size of ours, with the number of petitions we have, I think that's remarkable.
If you decide not to take a case, isn't there an implicit affirmation of the result
There isn't.
of that case below? There's
It
not.
has no precedential value, a denial of certiorari.
I think some of the public reporting on what we say confuses what we've done in the cert process. When we don't take a case, often it is reported that the Supreme Court today upheld or the Supreme Court today ordered, when in fact we've done no such thing.
Chief Justice Taft said that 2 courts is enough for justice as between the individuals, your trial and at least 1 appeal. For this court to intervene, there ought to be something more than just a sense that one of these parties didn't get quite what they should have gotten under the law.
What was it like the first time you ever went into the conference room? I mean, it's a mystery to everybody else. And then suddenly you're appointed to the court as your first conference.
That first conference was the most striking moment of the entire procedure as far as I was concerned, because all of a sudden I was sitting at the table with the 9 justices actually participating in resolving some of these very difficult issues. It was just an electric moment for me.
You feel very, very daunted by the presence of 8 people who've had a lot more experience at it than you've had and a lot more knowledge of it. But, you know, you're there, you have a commission just like the others, so you participate in the debate.
What's the first thing you do? You come into the room, you settle down to business, do you...
Shake hands.
Shake
the
hands.
first thing. Every time we meet, before we go on the bench or before we have a conference, each justice shakes every other justice's hand. That's good, because I think when you touch someone's hand, you're less likely to hold a grudge, if you will, should we end up disagreeing on the merits about something.
Let's assume now oral argument has taken place, and now in conference you're about to actually take up the final disposition of that case. What happens?
Well, I begin the discussion by briefly outlining what seem to me the issues in the case, and everybody has their say. And at conferences I used to participate in before I became Chief Justice, there tended to be cross-questioning and people speaking twice before anyone had had a chance to speak once. And since in my 14 years as an Associate Justice, I rose to the rank of 7th in seniority, which I'm sure is some sort of a record for creeping rather than walking, I had been frustrated by that. And so I determined and pressed as hard as I could on my colleagues to have a system where everybody spoke once before anyone spoke twice. And I think we pretty much have that now.
Do you find yourself leaving the conference sometimes with a different view of a case from how you came into it?
The approach that I like to take is to have an answer for each case before I come in, and to have that in an outline form, so I know how I'm going to decide the case. From time to time, that view changes in conference, but my views don't change that often in conference.
One of the difficulties every justice faces is that over time, it's as though we have walked through a patch of fresh concrete. We've left footprints behind us as we go with some of the opinions we've written, and then it becomes less open to change.
I did want to ask a question about the mystique of the court. I take it the court prides itself on keeping some distance between itself and the larger public.
I take issue with that. I think the court is remarkably open.
People think sometimes it's secret because they have in mind a legislature. A legislature doesn't produce all the reasons in public. A judiciary, a court, has no secrets because it's all out there in the opinion. And the inside story of a court is there is no inside story. It's people simply thinking.
One thing people should understand about the Supreme Court is that
The judges can't come in the morning and say, well, here's a problem we ought to deal with, the way a senator can, or a president can, or a governor, or a mayor. They have to wait for people to bring their problems to the courts. So you mustn't think that that's just a bunch of activist judges going in there to do something. It's because that issue has boiled up in the country, and it's been taken to the court. The court doesn't have to decide everything, but when issues knock at the door, sooner or later the court is going to have to say, yes, we'll decide.
The Supreme Court hears cases in public. Lawyers on opposing sides of each case are allowed 30 minutes to make their arguments before the court. Oral argument is an hour of high drama, where 9 of the nation's highest officials do their work in public.
Set the stage for oral argument. Basically, you come into the courtroom, what do?
I view the oral argument as simply an opportunity to ask the hard questions that the briefs raise in your mind.
You often think of the oral argument. You have a point in mind that you think may not have been brought out in the briefs well, but you want to be sure your colleagues don't overlook.
That's so important.
Well, ask a question to bring it out, and you're not necessarily trying to sell everybody on the position, but you want everybody to have at least the point in mind.
When the people come in this room, the public, to see our arguments, they often see a dialogue between the justices asking a question and the attorney answering it. And they think of the argument as a series of these dialogues. It isn't that. As John points out, what is happening is the court is having a conversation with itself through the intermediary of the attorney.
Mm-hmm. Let me put myself in the shoes of a lawyer. I'm here arguing a case for the first time. What do you expect me to do? What are you looking for from me?
Well, first you want to crank the lectern up or down. So
first I'll adjust it to the appropriate height.
I think really you should have asked Ruth to answer the question, because, you know, she's argued more cases before the court than the rest of us combined.
Oh, absolutely.
This is really the experienced advocate.
And won most of them, too.
What was it like to stand here and argue a case?
The first time I argued a case here, I didn't have lunch. I was first stop in the afternoon because I didn't know whether I could keep it down. I was initially terribly nervous. And after about 2 minutes into the argument, I looked up at these guys and I said, I have a captive audience. They have no place to go for the next 2 hours. They must listen to me. And it was a feeling of power. And then there was the challenge of rolling with the waves, sometimes the punches, trying to elicit what's in the decision-maker's mind rather than sticking to a prepared spiel. I think it's a good idea to have a great opening sentence and a great close if you have time.
Let me ask how you react to a lawyer.
It's a very impressive, almost awesome experience standing there in that wonderful courtroom with the justices looking down. Until the first question, there's this perhaps tension, and then it falls away. And the most exciting experience in arguing before the court is feeling that there are 9 people and yourself, and you're having a conversation, and you lose a sense of there being anybody else in the courtroom. It's a remarkable experience.
Now, American lawyers usually argue before either 1 judge, sometimes 3 judges, occasionally 5, but to argue before 9 is a different experience because you're arguing before a corporate group, and they all have their own ideas, and they ask you questions, and they use you sometimes as a post office box to talk to each other, and one justice has one idea that he's pursuing with questioning, and another justice will have another idea that she's pursuing with questioning, so that you have to simultaneously juggle in 30 minutes, sometimes 3 and 4 different lines of thought being drawn out of you by the justice's questioning.
There's an old principle. There are 3 arguments. The argument you planned to give, the argument you gave, and the argument you wish you had given when it was all over.
We have a luxury on this court nowadays of just plucking out of that very complicated case the one issue that seems to us of national significance and just concentrating the entire oral argument and all the briefs just on that one issue. That's a great luxury.
People will sometimes ask you, does oral argument make a difference? Of course it makes a difference.
Makes a lot of difference.
It has to make a difference. That's the passion and the power and the poetry of the law, that a rhetorical case can make a difference because abstract principles have to be applied in a real-life situation, and that's what the lawyer is there to remind the court about.
Even though critical
Within a few days after hearing arguments, the justices gather in their conference room to vote on the case. In this room, the 9 are alone. There are no law clerks or even a secretary. After they vote to decide a case, one of the justices on the majority side is assigned to write an opinion explaining the legal reasons for the decision. Opinion writing is the most time-consuming part of the justice's work. The court's reasoning in a written opinion binds all other courts as they decide future cases. Law clerks assist in researching and drafting opinions, as well as preparing for oral argument and screening the flow of new petitions. In addition to the majority opinion, any justice may write a separate opinion, dissenting from the decision, or concurring in the result, but disagreeing with the reasoning. Normally, a first draft of the court's opinion is finished in about 4 weeks. Opinion drafts are sent to all 9 justices. A justice may redraft a dozen or more times in the effort to persuade the others to join the opinion. Revisions and adjustments may go on for months as the author tries to accommodate differing views. Compromise is inevitable. On difficult cases, a justice switches sides, and on rare occasions, the majority becomes the minority. With rare exceptions, the court's tradition is to announce decisions and release opinions for all current cases by the end of the term in late June.
Yes. Thank you. 95566.
As the justices announce their decisions in the courtroom, the public information officer is notified by telephone to release copies of opinions to the press. Working against deadlines, reporters attempt to explain briefly what the court has decided and the reasons.
They're books. One is 80 pages long, the other one...
Supreme Court correspondents rely primarily on the court's written opinions, which run from a few pages on a unanimous decision to 80 pages or more when a divided court writes separate opinions. Within hours, or even minutes, they will be in print or on the air, explaining what the court did and its potential impact for millions of Americans.
Scalia wrote the opinion along with Rehnquist, Kennedy, Thomas.
Decisions on civil rights, criminal procedure, taxes, labor law, business.
One from Texas and one from North Carolina. In the Texas
when the Supreme Court speaks, by and large, people obey. And that unspoken contract is one of the hidden keys to our freedom. If the court ever stopped defending the Constitution, or the people ever stopped listening, then one of the treasures that keep this the freest nation in the world would cease to exist.
People see in that institution a willingness to protect the unpopular, to stand against the temporary political tides, a concern for principles beyond today's politics. People want to know that there's some institution in this country that's taking the long view.
Most people are willing to accept the fact that the court tries to play it straight. That acceptance has been built up by the preceding 100 justices of this court, going back to the beginning. We are, in fact, trading on the good faith and the conscientiousness of the justices who went before us. The power of the court is the power of trust earned, the trust of the American people.